Welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions. Presented by Wasinger Law Office. Join us as we unravel legal complexities and secure your family's legacy.
Hello and welcome to Out of Court and Out of Conflict, your guide to estate law and probate solutions by Wasinger Law Office. Join us today as we unravel legal complexities and secure your family's legacy with experienced attorney Matt Wasinger. Matt, thanks for being here.
Thanks for having me, Kevin. I appreciate it.
So, probate. A lot of people have some misconceptions and misunderstandings about what exactly it is. Can you shed some light on that?
Sure. One of the analogies I use is probate is like holding all your assets in your arms, which is if you have no estate planning or just a will goes to probate. You fall down, something happens to you, fall down, it goes everywhere. You've got to go to court, which is probate court, for a judge to find out what you have, what you owe, and who gets what. So in a more convoluted way, it's a lawsuit against yourself to go find out how your assets should be split up. And this is completely public. Everyone has to go through it. If you have a will or you haven't titled your assets in a way that have skipped probate, it's expensive and it's not a lot of fun. It violates our overarching goal, which is out of court, out of conflict.
Okay. Well, my next question was going to be about people being afraid of probate, and then you just said it's a lawsuit against yourself. So I guess that kind of answers the question of why people are afraid of it. But is it really as bad as it seems?
It can be. The only time that probate moves smoothly is if everybody is 100% on the same page, everything is done timely and properly, and everything gets filed and moved along. But even then, if everyone's on the same page and no one's fighting throughout probate, in Florida specifically, it can take 12 to 18 months to get through it. And part of that is just how busy the court system is. It's about getting hearing dates. It's about getting in front of judges, have judges having time to review what you put in front of them. So it just takes a long time. And more importantly, it's expensive. I mean, probate costs for attorney's fees are statutory. That means the law lists out, if you have X number of assets, it's going to cost this much. If you have X number of assets, it's going to cost this much for attorney's fees. And the goal there was to make it consistent across the board. So you didn't have to shop for attorneys necessarily based on their fees alone. So people weren't overcharging, undercharging, going through it. But the difference between probate and, say, the estate tax is based on your net worth. So they're subtracting what you owe. Probate attorney's fees are based on your gross assets because they're handling both what you have and what you owe. So they have to give it both ways. And that is the simplest calculations take about 4.5% of your gross worth. So it doesn't matter if you've got $1 million in assets and owe $999,000, you're going to pay based off that $1 million, your gross worth. And so that could be $30,000, $40,000 in attorney's fees alone, just if everything goes smoothly, just the statutory costs. So it is not something that you necessarily want people to go through or deal with, because that's where all of the conflict ends up happening. Sometimes people think, I don't have that much, everybody gets along. I've seen people fight out for months over 10 grand. They just drag out court cases. And every time someone's fighting, attorney's fees are going up, costs are going up, the process is taking longer. So it can be a real nightmare. The other analogy I use is it's basically a divorce court for the deceased, because they're going through and everyone's chopping up what everyone has. And hopefully everyone gets along and the process goes smoothly. But more often than not, people are fighting over either a lot of things or very little things, but fighting just as hard for those things. Yeah,
I think that's whether family, friends, whatever. It's like, that won't happen to us. We get along great. Yeah, I'm sure you hear that all the time.
Yeah, and it's pretty normal. It's not always the family members themselves. Sometimes it's a significant other in the ear of that family member and thinking that they need to get involved. And then that just creates a whole nother rift. So even if the parents or the people that are passing away, leaving their assets, think everyone's on the same page, it often doesn't end up that way.
All right. So let's talk about how we can avoid this. So in Florida specifically, how can proper estate planning avoid dealing with probate?
The only way to properly ensure you skip probate is with a trust, a revocable living trust. So if a will, just like I said, a will has to go to probate. The will just tells a judge how you want your assets to go. It doesn't prevent you from going to probate. A trust can prevent you from going to probate. So if a will is holding everything in your arms, a trust is one of those radio flyer red wagons. You're putting stuff in and out of your trust as you're alive. And if something happens, you fall down, your successor trustee just picks up that handle and keeps going. It's all handled privately, probably an attorney's office somewhere, just everyone divvying up what needs to be done, the trustee taking over the trust assets. If you have a will only and you're not willing to go with a trust, there's ways that you can try to get around probate, either titling assets jointly with somebody else. So when you pass, it just goes directly to them. Or you can add, well, a lot of people like to add their kids to their deeds and things. So it just goes straight to them, bank account, same way. The problem with that is you end up with the chance that, let's say, those kids pass before you, and then they can't, then that account is still going to probate no matter what. Or on top of it, anything that you have access to, your creditors have access to. So once you add your child or significant other that's not your spouse to an account, if they get in trouble, let's say they get in a car accident and cause a bunch of damage that someone comes after them for, that account that they have access to that you've put on just to avoid probate, their creditors have access to. So your money could be at stake when it comes to that. And the biggest thing with the house is once you add somebody else to it, if you pass your house down in Florida, say you give it to your kids after you pass, they'll get a step up in basis, meaning the value of the house will be considered the value of when that person passed. And anything that goes over and above that, that's the only difference between the sale price and the actual price. It's stepped up to the value of the price of the asset when they died. But if you add someone right away, you lose that step up in basis. That means that anybody that's added to it, let's say the father dies, the son gets the house, they are going to sell it. They're going to sell it based off of the difference in price. The value that they are getting is going to go off of the original purchase price that the father had at the time that they bought it, not at the time he passed. So there's a whole bunch of little benefits of not doing it though that way with wills, but there is a chance. You can still try to avoid it by titling assets differently with a will.
Got it. Matt, you're very good at analogies. It helps a lot when trying to the radio flyer wagon and all that. It helps. This is complicated for most people, so that's really helpful. So tell me, you've kind of touched on it a little bit, but what exactly does the probate process look like in Florida specifically?
In Florida, it's pretty much everywhere. It's all public. So it's public in a case system. Anyone can go down and see what's going on in your probate case. And in Florida, it's 12 to 18 months minimally if you've got any assets. And like I said, it's very expensive. So the problem you run into with probate is what happens a lot. Someone pops up. And it could be a friend. It could be an heir cousin from somewhere else that says, "Oh, hey, I'm owed 10 grand. Kevin said he was going to pay me 10 grand. I've got this note right here." Everyone involved could know that this is completely not true, that it's not worth it. It's fiction. But the judge has to go through the steps. Everyone's got to go through the steps of trying to find out, what is this real? Where'd it come from? How'd it go? And that's where the conflict starts to come in. There's law firms in the state of Florida, more in the southern part of the state, that do nothing but try to track down heirs across the country to assign them their potential interest in a probate, and then they jump in and start fighting for the money in the probate case. You've got those things happening all of the time. And once that happens, that's just dragging everything out. In probate, normally you hear about the celebrities that have gone through probate when they pass, and that's because it's all public. So Aretha Franklin is the example I use a lot. She had no estate planning done whatsoever. She had 4 different unsigned wills show up. 4. So they have to, even though we're trying to figure out, she never signed them, which one may actually be what her wishes were when she passed and was not. And it just goes on and on and on. And if you don't hear about celebrities when they ask anything going through probate, it means they set up an estate plan. So no one started fighting about it in court. So
what might delay or cause issues in a probate case, and how do you, as the estate planning attorney, help move this process forward? Well, the way I handle it is I don't get involved in probate cases. We handle everything on the front end. We set up an estate plan specifically to keep you out of probate. That's the goal. Now, that doesn't always work depending on what the client wants to do, because the clients,
goals take precedent over everything. But the only way you can properly avoid probate, or at least try to minimize the amount of fighting that probate would cause, is having an up-to-date estate plan that covers, not just the basics, not a DIY will that forgets to say, all right, what happens if this person I'm giving the majority of my estate to dies? Does it go to their kids? Does it lapse? Does it go to my other beneficiaries? Things like that when you're doing the DIY stuff, or maybe just attorneys that don't pay as much attention, it leaves holes there. So you're trying to constantly make sure that the holes are as small or covered as possible to avoid a long, drawn-out probate process, if that's where you're headed.
I feel like one of the mistakes that people will make that you'll hear a lot is, I don't really have that much. I don't have that much as far as assets go or whatever. I mean, I'm assuming that that's probably something that people would say. What do you say to people who use that logic?
That might be true, but you're still going to probate. And the other thing is, because it's expensive, sometimes the people with the least amount, if they're trying to get money to the people they care about, going through the probate process is something they can least afford, because it's locking up those assets until a court decides how they're supposed to go. And you're spending money that whole time trying to get that smaller piece of pie. You might not have a lot, but judging on the value versus of what you think is a lot versus others is a lot, probate can still be more expensive than you're thinking it's going to be, and take more of that money away from the people you're trying to take care of after you pass. And
the time and the commitment they have to deal with that for, you said 12 to 18 months or whatever. That's a long time.
Yeah. It's emotional roller coaster. Like I said, it's a divorce basically case that just can drag out indefinitely depending on what happens.
What other common mistakes do people make when it comes to probate?
The big one is everyone assuming that as long as you add somebody to an account, everything is fine. That's where the holes start to pop up. And the other thing is people thinking that their will override beneficiary designations. So you have a life insurance policy, or even your bank accounts, you have the ability to put a beneficiary designation down. So people will put, most of the time, their spouse or their kids or somebody on there. But their will has X number of things going to this person and X number of things going to this person. Beneficiary designations override a will. So no matter what's in your will, if your my life insurance is going to you, Kevin, but my will says it's supposed to go to my wife, that check's coming to you. And there's
Nice.
nothing anybody can do about it at that point.
Yeah.
Once they get it to you, it's there. So that's one of the big mistakes that people tend to make. They think that their will cover everything, and it doesn't matter that they haven't updated their beneficiary designations or account designations and things like that.
So it's a matter of making sure you have everything syncing up, whether it's your will
Right.
versus your everything. Yeah. Okay. That makes sense.
Yeah.
That makes sense. Should anyone ever attempt to handle a probate case in Florida by themselves?
I would never recommend someone handle a probate case on their own. It is there's just like me handling an area of law that I've never done anything in.
Mm-hmm.
It is a minefield but you don't even know where the mines are. You're guessing, and you're hoping that whatever you're doing is going to work out the way you need it to. And if you're going on your own, there's a chance it's going to cost you more money, be more expensive than if you had just handled it with an attorney to begin with. So we always recommend you find an attorney, especially because the fees are statutory. So you can kind of calculate where you think your fees should be. And if you're getting quoted way higher than that in some respect, then that's not an attorney you should be working with.
Good call. So what does your firm bring to the table that makes it so valuable that someone should never think about doing it on their own?
Ours is making sure that your estate plan is completely packaged all the way through. So we only do packages. We don't do one-offs. We won't do, if you come in and say, I just want to do a will, we won't do just a will, because you're missing things. You're missing your medical power of attorney. You're missing your healthcare power of attorney. You're missing, your living will. You're missing your durable power of attorney, which is your financial power of attorney. All of those things are part of the package that helps cover the holes that just a simple will miss, or things like that. And with a trust, we do the same thing. That's covering even more. We make sure that your assets get into that trust so you can stay out of probate. Because if it's not in your red wagon, it's going through probate. So we're trying to make sure that you put everything in there before we send you on your way. So our way of avoiding probate is giving you a comprehensive estate plan that makes sure that it covers the holes that could show up and have your family end up in probate.
That makes sense. It's more like a holistic approach to it rather than just going on a legal Zoom and things like that. You can do some of this stuff. And I imagine there's some horror stories of people who think that that's going to work out and it doesn't.
Of course. Yeah. The way most DIY legal stuff goes is you'll end up in court at some point, because that's just the nature of not knowing that area that you're in, with anything.
Yeah. There's some things you gotta just let the experts handle them. There's a reason that people go to school for a long time for this stuff.
Exactly. That's why I don't handle the electric work in my own house.
Yeah. I've done that before and it didn't always go well. I'm not gonna lie. I thought I hit that breaker right, but I didn't. And I was thrown across the room.
Exactly.
Well, thanks everyone for tuning in to Out of Court and Out of Conflict with experienced attorney Matt Wasinger. For more information or to connect with Matt, you can visit wasingerlawoffice.com or find him on social media. Also, be sure to hit that like and subscribe button and leave us a review in the comments. Matt, thanks so much for being here.
Thanks, Kevin. It's been a pleasure.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one. And be sure to follow us on social media.